This is English shorthand dictation number 363 and the dictation speed is 100 words per minute. Ready? Start. We have heard the learned counsel for the parties. The prosecution is based upon the dying declaration of the deceased. The said dying declaration is in oral form. It was made by the deceased to his brother Rajkumar and mother Usha Rani, who had reached the place of occurrence on being informed that the deceased was being beaten and assaulted by the accused persons near Raja Hotel. The dying declaration, as revealed by Rajkumar, was made by the deceased on the asking of the mother as to what had happened. It is in response to the above query that the deceased stated that Bunty, Manto, and Ajay have assaulted him with knife, dagger, and iron rod, respectively, whereas Jitu caught both his hands. The above dying declaration is in the shape of an answer to the question asked by the mother of the deceased as to what had happened to him when she saw him lying on the road in a pool of blood. The statement of the mother of the deceased also contains a similar dying declaration of the deceased. In addition to the above dying declaration, reliance has been placed upon the testimony of one of the eyewitnesses, Rahul. The said witness stated that the incident in which the deceased Guddu was killed had taken place between 8:30 p.m. to 9 p.m. on 08/06/2007 near Raja Hotel. He was returning from his friend's house, and when he reached near Shukla Hotel, he saw the accused persons, namely Bunty, Manto, Jeetu, and Ajay, beating Guddu. He tried to rescue Guddu, but the accused persons drove him out. He then rushed to the house of Guddu to inform about the incident to his family members, but he found no one at the house and therefore left for his home. It has come in evidence that Rahul is a relative of the deceased Guddu, and as such he is not a free and independent witness. He is likely to be an interested witness. The evidence reveals that he is a person with criminal background. He is involved in one of the cases registered under Section 324 and 326 of IPC. He has been charge sheeted under Section 3 of the Explosive Substance Act. He has avoided the process of the court and had been absconding for almost 7 months. In view of his above background, his testimony has to be considered with great circumspection and cannot be relied upon blindly without taking into account available corroborative evidence on record, if any. The evidence on record casts a serious doubt as to whether the place of occurrence or the Raja Hotel was visible from the Shukla Hotel, where the above witness was standing and from where he is said to have seen the occurrence of the incident. The above witness was not found at the place of occurrence by the brother and mother of the deceased when they reached the place of occurrence immediately after the alleged incident had taken place or at the time when the deceased was lying on the road. They have not mentioned about his presence, though he ought to have been there, as he had tried to save the deceased. Even the deceased has not mentioned in his alleged dying declaration or the statement given to his brother and mother that someone tried to save him or that the above witness Rahul had come to his rescue but was made to run away. Additionally, even the FIR does not mention the presence of Rahul. All these factors cast a serious doubt as to presence of Rahul, and the conviction cannot be based on his testimony alone. The FIR specifically mentioned that the incident was witnessed by Naveen and Amit, the friends of the deceased, who were with him at the time of incident. Both these persons have not supported the prosecution case. These two eyewitnesses to the incident were declared hostile, and as such, their depositions are of no use now. Now, coming to the dying declaration made by the deceased to his brother and mother, we find that the injuries sustained by the deceased were very grave. Dr. Abhishek Singh, who performed the post mortem at Medical College, Jabalpur, opined that the left lung of the deceased was punctured, causing respiratory failure, and the left lung was pale. The heart injury sustained by him could have caused excessive bleeding, and in that situation, the person would have died between 15 between 5 to 10 minutes of receiving such injuries or within a maximum of 15 minutes. The post-mortem report on record, which was duly proved, reveals that the deceased had died due to hemorrhage, shock, and cardiorespiratory failure. Apart from the injuries referred above, the deceased had suffered other serious injuries, not only on neck, chest, and abdomen, but also on the lower limbs from where bleeding had taken place. There was also an injury on the skull. Rajkumar, the brother of the deceased, is a lawyer by profession. The brother and the mother of the deceased had rushed to the spot only after receiving information of the incident from PW1, who, after seeing the accused persons assaulting the deceased, had gone to their house to inform of the incident. All this obviously could have consumed 15 to 25 minutes, which means that by the time they reached the place of occurrence, the deceased could not have survived so as to make any declaration. There is no specific material piece of evidence to establish that the deceased was alive or in a position to speak when his brother and mother reached the spot. In these circumstances, the dying declaration cannot be ex facie accepted to be correct unless it stands corroborated by any other cogent evidence. There is no material to corroborate the said dying declaration.